You're welcome to my channel. In this video, we are going to be introducing the third topic in company law or business law, which is raising the capital of the company. Companies are time and time again faced with the challenge of raising capital for the growth of the company. And for an existing company, new capital for such a company can be raised through very many ways, and the first is by plowing back profits without declaring them as dividends. Like, instead of giving them as dividends, you just decide to reinvest them in the business. Then by offering securities to the public, floating new shares, and then borrow from the bank or the government or insurance companies or finance houses. And those are some of the ways through which an existing company can raise capital. Let's first look at raising capital through selling shares to the public. Companies can raise capital by inviting members of the public to subscribe for shares in the company, and this is done through the issuing of a prospectus. Let's now look at the prospectus. According to Section 2 of the Companies Act, a prospectus means any document, notes, circular, advertisement, or invitation or offering to the public for subscription of the securities. A prospectus is that document that is issued to the public inviting them to come and subscribe to the shares or to subscribe to the securities of the company. And this was seen in the case of Nash versus Lind in 1929, it was concluded that for a document to amount to a prospectus, not only it must be delivered, but there must be some form of publicity with the aim of inducing subscription. So a prospectus must be delivered to the public, and there must be some form of publicity with the aim of it inducing people to come and subscribe to the shares or securities of the company. Let's look at the legal aspects of a prospectus. A prospectus must be approved by the Capital Market Authority, and then it must be delivered to the registrar for registration when it's signed by every director, and this is according to Section 60 of the Companies Act. Next is the statement in lieu of a prospectus. If a public company is not issuing a prospectus on its formation, it then must file a statement in lieu of a prospectus with the registrar. And a statement in lieu of a prospectus is a document prepared by every such public company which does not issue a prospectus on its formation with the registrar before allotment, and it's signed by every person who is named therein. So if a public company doesn't issue a prospectus on its formation, it must issue a statement in lieu of a prospectus. And the statement in lieu of a prospectus gives the same information as the prospectus. It is signed by all the directors or the proposed directors, and in case the company hasn't filed a statement in lieu of a prospectus with the registrar, it's then not allowed to allot any shares or debentures. Allotting, it's like distributing. If it doesn't file a statement in lieu of a prospectus, yet it also didn't issue the prospectus, it can't be allowed to distribute shares or debentures. Let's look at the information that is contained in a statement in lieu of a prospectus. First we have name of the company, then the statement of capital, there is description of the business, name, address, and occupation of directors, estimated initial expenses of the company, the names of vendors and details of property, material contracts, directors' interests, and then the minimum subscription required by the company. And that was all about the introduction to topic 3 of company law, which is raising the capital of the company. Thanks for watching. Don't forget to subscribe, like, comment, share with your friends, and watch my next video. We shall be talking about The methods of issue of shares to the public.